Uh-oh. We already had an uh-oh moment with Judge Cannon and how she handles a trial, which if it's any precursor to how she's going to handle the May trial of Donald Trump, strap in. We're going to be in for a bumpy ride because once again, Judge Cannon has showed her inexperience. Things that kind of judges work out over time after they hit the bench. You know, it's not that judges are error-free. They're not infallible. They're not the Pope, so to speak. But she doesn't have a lot of time here to learn how to be a sophisticated, educated, and mature member of the federal bench in time for all the pressure testing that Donald Trump's going to be doing with his lawyers as he applies a fire hose to the process, just like he did to our democratic guardrails to stop the peaceful transfer of power. What am I talking about? What's Popok talking about? He's talking about a case in June. We want to get an idea of what Aileen Cannon, Judge Cannon, is like in a courtroom presiding over a trial. She's only presided over now 4 trials in total in the 3 years that she's been a federal judge. Let me repeat that. She's done 4 trials. The other 224 cases in front of her have either settled, pled out, or haven't gone to trial. She only had 4 trials when she was a federal prosecutor. Yeah, she was a federal prosecutor in her entire life. So she's only done 8 trials. Let me give you an idea. She's a judge. Her job, her business is trying cases. I'm a trial lawyer for 32 years. I've tried over 30 cases. Okay, so we'll put that into context. What did Aileen Cannon do wrong? She didn't just do a little wrong. She did a lot wrong in how she handled a recent federal criminal trial in her courtroom, and she committed not 1 but 2 fundamental, what's called structural errors, meaning they go to the very heart of the U.S. Constitution, and they are reversible error if they're pursued at the appellate court level. In appellate court level right above her, the 11th Circuit that's already chastised her, not once but twice, related to her interference and her improper exercise of equitable jurisdiction when the Mar-a-Lago search warrant happened, when the indictment was far off in the distance in Mar-a-Lago, almost a year in the distance, and she tried to interfere with an ongoing criminal investigation by the Department of Justice and the FBI, for which she has no power and no right as a trial judge. That Aileen Cannon, that 11th Circuit Court of Appeals. She had a case in front of her in June involving, and the facts here don't matter except that it is a serious criminal case. But the facts are you have an Alabama man who was indicted for running a website that showed child sex abuse images. Disgusting, presumed innocent until tried, I will remind you. And the 2 issues that came up is every judge, this is like Judge 101. In fact, they go to training academy before they go on the bench, and they go to continuing judicial education courses. But she's only been on the bench for a short amount of time, and most of that was taken up with COVID, where nobody was having trials for a long period of time. And this is only her 4th trial. And she screwed up jury selection, goes to the 6th Amendment right for a person to have a fair public trial. And she screwed up who could be in the courtroom, the public aspect of the 6th Amendment right to a public trial. She wouldn't allow the public in the room. She closed her courtroom for the beginning of the trial and the jury selection process. That is such a big no-no under the U.S. Supreme Court precedent that it's referred to as a term of art as a structural error, a reversible error of the fundamental constitutional kind. So fundamental to our system of justice, right? You don't even have to show a harm. It is presumed that you were harmed by the fact that there was nobody in the public. We don't do secret trials in this country, right? I know that may be a surprise to some people who follow dictatorships very, very closely, like Donald Trump, but we don't do secret trials. And so when Judge Cannon, at the start of this process, effectively closed her courtroom and wouldn't allow the family of the defendant to watch the jury selection process or anyone else from the public that was interested, because there weren't, and I'm not making this up, weren't enough chairs in the courtroom, she violated the U.S. Constitution's 6th Amendment rights of this individual. And it's not like she wasn't reminded in real time, not just by the prosecutors of the U.S. Attorney's Office for the Southern District of Florida. She was reminded by the defense, both the defense and the prosecution. told the judge, the bridge is out ahead. Don't drive down that road. And the judge rejected both of those. The defense stood up and told the judge, you can't close the courtroom. You got to let the family members and other members of the public be in the courtroom. I don't care how many chairs are in the courtroom. It's a Sixth Amendment constitutional right. You know what the judge said in response? Noted, and your objection is overruled. Federal prosecutor got up. You know, this is one of the rare times defense and prosecution joined together to tell the judge she's making an error of reversible epic proportion related to the Sixth Amendment right. Same thing Donald Trump's going to have down the road. And said, Your Honor, there's Supreme Court precedent. You got to let the family watch the jury selection. You got to open some chairs. What about those two chairs right there? The judge says, well, I like those for law enforcement. And she effectively kept it closed. And therefore you have structural error, constitutional epic proportion, reversible error, number one. I get it's only her fourth trial, but like, I don't know, get how to be a federal judge for dummies up there on your bench. Let your bailiff get stronger personnel to help you. Your bailiff, the sheriff, the whoever's in the room with you, your clerk, have them whisper in your ear or write you a note or shoot you a direct message. Judge, you got to let the public in the room. It's a Sixth Amendment right. Right? It's shocking that she was not only a federal prosecutor, but she was an appellate lawyer for the Department of Justice. I mean, she should know these issues. You learn these constitutional law 101 in law school, a core course. But that wasn't her only error in the same trial. I mean, occasionally I've been involved with cases where I argue there's been a reversible error by a judge, but never about structural violations of the Constitution. The second one is jury selection. So now she's got the public barred from coming into the room, and she's conducting, in effect, a secret trial. And now we get to the jury selection process. Let me give you a primer on jury selection process. In case you have never seen jury selection process, haven't been a juror, it's really relatively straightforward. You pull in groups of 15, 20, whatever the courtroom can handle, of potential jurors. They're not yet jurors. It's called a panel or a veneer of jurors. And they are questioned both by the federal judge, usually with a questionnaire or whatever her standard operating procedure is for asking questions of the jury, to give name, rank, serial number, address, occupation, profession, where do you live, do you know any of the defendants, do you know any of the lawyers, do you know any of the prosecutors, do you know me, do you know my courtroom personnel, questions like that. And then after she runs through 15 or 20, in federal court anyway, each side, prosecution and defense in a criminal case, are allowed to question the jury, potential jury as well. That process, whether you're in a civil case or a federal case, is called voir dire, right? French, just so, they can charge a lot for law school. And so in the voir dire process, in state court, lawyers have kind of free run. You can basically try your whole case almost through the voir dire process. And you can do the themes in your case. You can see the reactions. And what you're doing and your team is doing during this process is that you're jotting down notes about body language, facial reactions, responses. You have the juries, in cases like this, you have their name and you have their number, their seat number. Juror 1, Juror 12, Juror 15. And you'll ask questions. Juror 15, you seem to react when I was asking Juror 1 about whether she gets her news from Fox News or what her news sources were. Where do you get your news from? And you sort of interact with them. And you're allowed to do this. In a federal court, it's a little tighter rein. You're a little more roped in by the judge on that. But you can get, what you're trying to do is find people that are going to be with you or against you, or at least they're not going to be neutral. You want neutral, fair application of the law to the facts. Nobody with a predisposed notion of guilt or innocence. That's your kind of perfect juror. But let's be honest, if you're the defense, you're looking for somebody you think might side with you based on some questions you're asking, and the prosecution's looking for somebody to do the same thing, right? And in cases like this, they'll get specific. Have anybody in this room, because it was a child sex abuse photo case, has anybody here or in their immediate or extended family ever suffered sex abuse, child abuse? Hands go up, people get disqualified. And there's two ways for people to get removed from the jury pool, right? It's either for cause, meaning they just say something that's so inconsistent with their ability to be fair and impartial that they have to be removed, and then they're kind of stricken by the judge, if you will. And then each side gets challenges. They're called peremptory challenges. And usually you get 5 or 6 a side. And so you can get rid of at least 6 each side, let's say. And then the judge can get rid of others for cause. And then eventually you get down to your jury. It's usually 6, 9, or 12. Federal court's usually about 9. And so that's your jury, and that's your jury selection process. That's a long-winded way of telling you the jury selection process. What you're supposed to do at the start of the jury selection process is you're supposed to swear in all of the potential jurors under oath, under penalty of perjury, that whatever they're going to say in response to these questions in voir dire is true or not. And she didn't, Judge Cannon, swear them in. Let me let that land on the table for a minute. This is I don't even know if this is Judge 101. This is Judge 001. Swear in people that are going to give testimony and responses in response to questions in federal court where you're required to tell the truth, but you got to swear them in first. She didn't swear in the jurors. Reminded by the prosecutor that she screwed up. Reminded by the defense lawyers that she screwed up. The only thing that bailed her out, the only thing, is that after a lunch break and after she closed the courtroom, fundamental constitutional violation, had them participate, the lawyers, in voir dire jury selection without swearing in the jurors who were giving the responses to the questions. After those 2 fundamental structural reversible errors, the defendant cut a deal and pled guilty conditionally to his crime, meaning there would be no need for a trial. It didn't fix the fact that up until that moment, the judge created an unconstitutional secret trial, but it's not going to be the grounds that are going to be appealed, because this defendant pled guilty conditionally, reserving for himself the right to only appeal one issue. It has to do with some evidence that was suppressed by the judge on a motion. And the prosecutor said, sure, we'll take that deal. We think you're going to lose that appeal, but that's the only ground for appeal that you will have. Otherwise, you have pled guilty and you'll be sentenced in several months from now, subject to the appeal with Judge Cannon. So the defense lawyer made a strategic decision not to use the reversible error of the closed trial and the failure to swear in the jurors as grounds for a future appeal, because he cut a deal, which I guess he presumed with the client's consultation was better for him. But this is a blueprint. And if it is a blueprint for how she's going to handle what could be her 5th trial only, having sat on the bench in 3 years or 4 years, in Donald Trump, U.S. versus Donald Trump, we're in for a bumpy ride. Strap in. This is going to be a white knuckle trial, because she's learning like on the fly. And sometimes, I'll tell you straight, judges who are weak surround themselves with weak personnel, so no one's there to save them. If I were a federal judge or a trial judge, and it was my first go around, I would firstly make sure that I had a really strong, competent, sophisticated, educated deputy, courtroom deputy, and courtroom and clerk, and hire people that had experience at the federal court level to help me through that process. It's okay, right? Even the pilot of a plane has a co-pilot, right? Flight attendants, people on the tarmac helping them get the plane in the right spot, air traffic controllers helping get the plane up and down. It's okay, right? You're not responsible for everything, but you should have somebody. And if you don't have those people, then make a checklist for yourself and check it off on the fundamentals of what you got to do in a trial, and make sure you hit each one of those. No one has to see you do it, but have it up on the bench with you. That's my little free advice on this particular hot take, in only one place where we follow right at the intersection of U.S. law and politics, only on the MeidasTouch Network. Free subscribe to the MeidasTouch Network. Go over to their website where we accumulate all of our writings and podcasts on the MeidasTouch Network at MeidasTouch.com. You can then go and find me and all my content on hot takes just like this one at the intersection of law and politics on the MeidasTouch Network YouTube channel. Free subscribe. Go over to playlist, find Michael Popok. You'll find 300 of my hot takes sitting right there. I bring my 32 years of trial experience in federal and state courts, trial strategist experience, right to you here. I do it on Wednesdays and Saturdays, also on a podcast on MeidasTouch Network we call Legal AF. You knew that. I co-anchor it on Wednesdays with Karen Friedman Ignifilo, Saturdays with Ben Meiselas. Pull it all together. It's a full 1 hour or more podcast you'll find interesting if you're finding these hot takes interesting. And you can then pick it up on audio wherever you get your podcasts from, on all audio platforms from Spotify to Google to Apple. And then if you like me, Michael Popok, follow me on all things social media, including now on Threads at MS Popok. This is Michael Popok. Until the next hot take, Legal AF.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.